Your take then on the jury saying maybe not conscious disregard, but an intentional disregard that led to recklessness.
Well, this conscious disregard of risk is required for both those criminal charges, first and second degree manslaughter. It did not exist in this case, so she ought not have been convicted on either. Indeed, these charges should have been dismissed before trial. She ought not have been tried on these charges. What the prosecution effectively did was they removed from the law this requirement that she consciously disregarded a risk of death to Daunte Wright. That is what manslaughter requires, reckless manslaughter in Minnesota and every other state. And the prosecution effectively told the jury on closing and rebuttal, no, that's not what's required. All that's required is that she made a mistake, that she should have known that she was making a mistake, that theoretically there was some risk. But reckless manslaughter requires that you knew there was a specific risk of the outcome that happened, the death of Daunte Wright, and you consciously disregarded that risk. There wasn't even evidence that she consciously disregarded weapons confusion. There was no evidence that she consciously disregarded that. So what they were really arguing is, well, she should have known that she could confuse her weapons. She should have known that she might have come out with her gun instead of her taser. But should have known is the standard for negligence, not the standard for recklessness. Recklessness is not only should you have known, but you did know, in fact, in the moment, and decided to do it anyway.
You had apparently what he said. The jury they listened to the expert. I think it was the expert, the paid expert from the prosecution who tried to say she just didn't really have self-defense available to her. She didn't have
no force would have been authorized according to the prosecution expert.
Right. This is a hired, paid gun who made, $10,000 for giving this testimony. It's amazing to me when the jury
also
speaks
testified
out.
In the Derek Chauvin trial, by the way.
Exactly. And this is a guy who, by the way, hasn't had much of a police career behind him.
No, briefly, mostly behind the desk 15 years ago.
Okay, so he's going to speak as, an expert on what an officer in the moment is supposed to do as a guy's trying to drive away with another cop hanging half out of the car and the risk to him. So the jury buys it and they disregarded. You tell me, why did they disregard the argument that you and I last spoke about? Last time you were on talking about this case, we're talking about how the defense seemed to be trying to make the case and the fellow officers were backing it up, that she could have fired her service weapon at him. She could have intentionally fired her service weapon at him. And this could have been a justified shooting, given that he was almost killing a cop and driving away during an act of arrest.
Yeah, it's not a bad emotional argument, but it's not a very strong legal argument because the use of deadly force in defense of yourself or of others can't be an unintentional act. It has to be an intentional act. You're intentionally using deadly force to neutralize some unlawful deadly force threat to innocent people. And she did not do that. She did not use deadly force intentionally. So that fundamentally undermines that legal argument. The key legal argument here, and there's really only one, is that Kim Potter did not consciously disregard a risk of death. She made an error. She made a mistake. And frankly, she ought to be held civilly liable for that error. There's no question in my mind she committed an act of negligence. And in the civil court, she should be held liable for that. But she did not commit a criminal act on the facts of this case.
I think this is the fault of Keith Ellison. I really do. I don't blame the jury. I think they went with what they were presented. The law presentation was a mess. The jury instructions were a mess. I think the judge showed absolutely no courage in presenting a very clear, concise...
Absolute failure by Judge Chu. It was despicable. The prosecution explicitly misstated the law to the jury in their rebuttal. And the rebuttal, folks, by the way, there's no opportunity for the defense to correct at that point. The last words the jury are going to hear are the words from the prosecution in rebuttal. And the prosecution simply misstated the law. So either they misled the jury into that guilty verdict, or they simply provided the jury with an excuse the jury might have been looking for to return a guilty verdict.
I don't know. I don't feel like the jury was looking for an excuse to find her guilty. In reading this guy's interview, it seems like they were genuinely searching for the right result. And he talks about how the entire time they were debating the law, the jury instructions, that there really was no factual dispute about what happened here. And therefore, the obligation on the lawyers and on the judge to give them crystal clear jury instructions was higher than ever, right? And I don't think this judge did that. But I also think Keith Ellison never should have brought this case. He's an activist. He is a partisan hack. I'm sorry, but he is. And he made clear he wanted to go after her to make right sins of other people. This was in the wake of George Floyd. He's an activist guy. She's a white police officer. Daunte Wright was a black man. And he decided to make an example out of this woman who in 26 years as a cop, never had a smidge of misconduct on her record or even alleged against her. He decided to make an example of her for other people's sins. That's my take on it. What do you make of it?
Yeah, I agree. Absolutely. And frankly, much like the George Zimmerman case, if Trayvon Martin had not been killed by George Zimmerman, Trayvon Martin would have been facing felony charges after that event. In this case, had Daunte Wright not been killed in this encounter, he would have been facing very serious charges for his attempts to flee the police, fight the police, resist lawful arrest. But it became a political persecution the moment he died, and therefore there was political capital to be made by people like Keith Ellison in bringing this prosecution.